Donald Trump has threatened to blow up the entirety of Iran's South Pars gas field if Tehran strikes Qatar's gas infrastructure again. In a post on Truth Social, the president said the US knew nothing about an Israeli strike on the South Pars gas field, the biggest natural gas field in the world, which then sparked attacks by Iran on Qatar's Ras Laffan facility, the world's largest gas hub. Shortly before the post, Iranian state television reported that they had struck the Ras Laffan complex for a second time. Qatar Energy confirmed the facility sustained further significant damage. These here are pictures of the aftermath of the initial strikes. Huge fires could be seen for more than 30 kilometers.
Hey, welcome guys to Dr. John Podcast. Right now in the United States House of Representatives, something is happening that constitutional scholars are going to be dissecting for decades. Two sets of impeachment articles, filed simultaneously, pointed in opposite directions. One aimed at Donald Trump for threatening judges. The other's aimed at federal judges for ruling against Donald Trump.
Iran said it targeted the facility and others in the region in response to the Israeli strikes on its own facilities at the South Pars gas reservoir. Oil prices have leapt as a result, up 5%. Our North America correspondent Peter Bowes analysed the president's Truth Social post.
It is quite a lengthy Truth Social post, and I think it's worth sadly going through some of it in detail because I think it tells us quite a lot about the current mood of the president. He says Israel had violently lashed out at the South Pars gas field, which, as you said, is one of the world's largest natural gas fields. He says lashed out of anger for what has taken place in the Middle East. The
impeachment mechanism, that constitutional weapon designed for the rarest of circumstances, is being fired from both sides of the battlefield at the exact same moment. This isn't normal politics. This is a two-front constitutional war unfolding in real time. And the story we're tracking today is the most extraordinary institutional clash modern America has ever witnessed.
The Israeli strikes at South Pars. And Qatar has seen its Ras Laffan energy facility targeted multiple times. Fires are now under control, according to Qatar. And here in the UAE, there was damage to some gas fields due to debris from intercepted attacks. And you can imagine there's a lot of anger about these strikes and these Iranian attacks, so much so that following a meeting of foreign affairs ministers in the capital of Saudi Arabia, Riyadh, there has been a joint statement that has been issued by a group of Arab nations and Islamic countries. So not only Qatar, UAE, and others that you might expect, but also countries like Pakistan, Syria, Lebanon, Jordan was part of that group as well. And they've condemned these attacks by Iran, reserved their right to self-defense, and they've...
Let me walk you through the exact sequence because the details here are absolutely critical. Back in early 2025, a federal judge named James Boasberg did something that judges do every day. He issued a ruling. He temporarily blocked a mass deportation program pushed by the Trump administration. It was a legal decision based on his reading of the law, but the response was anything but routine.
Urged Iran to halt these attacks immediately. They've also asserted, they've also shown support for Lebanon and have condemned what they've called Israel's expansionist behavior in the region. Now, it's worth remembering that the reason these countries, particularly in the Gulf, are so taken aback isn't just that Iran is targeting them because of their ties with the United States. They feel like they've really been pulled into this war unjustly, because of the fact that some of them, Oman of course in particular, have played mediating roles between Iran and the West in the past. And so the
Donald Trump went nuclear on social media, demanding Boasberg's impeachment in all capital letters, because when a president uses all caps to call for a judge's removal, you know we've left the realm of normal political discourse. The message was clear: rule against me, and I'll come for your job. Then came Chief Justice John Roberts, and let me tell you, Roberts does not speak lightly. He issued a public rebuke making crystal clear that impeachment is not, and never has been, a remedy for simply disliking a judicial decision. He warned that these kinds of attacks don't just threaten individual judges, they threaten the independence of the entire judiciary. It was the Chief Justice of the United States standing at the constitutional ramparts and saying, in effect, this is not how our system works. But here's where the story takes a sharp turn from alarming to genuinely terrifying. Within days, a freshman Republican representative named Brandon Gill filed articles of impeachment against Judge Boasberg. Not against Trump, against the judge. He accused Boasberg of high crimes and misdemeanors for temporarily blocking the deportation plan. And Gill wasn't alone. 5 other House Republicans co-signed the resolution. Think about what that means. A judge does his job, applies the law, issues a temporary block on an executive action, and 6 members of Congress respond by trying to remove him from office. Now, if that was the whole story, it would already be a constitutional crisis. But it's not even half of it. Separately, the Trump Justice Department launched an internal operation that fundamentally perverts the purpose of the nation's top law enforcement agency. A senior official directed all 93 U.S. attorneys' offices across the country, every single one, to compile examples of what they called egregious judicial decisions that hindered Trump's agenda. The explicit purpose? To help the DOJ decide which judges to refer to Congress for potential impeachment. This wasn't some rogue actor going off the reservation. This was a systematic directive from the top, turning the Justice Department into an opposition research machine targeting the federal judiciary. And the Deputy Attorney General had previously described the administration's approach to the courts as a war. A war. Those aren't the words of an executive branch that respects co-equal branches of government. Those are the words of an executive branch that sees the judiciary as an enemy to be defeated. Let me pause here and make sure you understand what the DOJ operation actually means institutionally, because this is where the story gets deeply, deeply alarming. The Justice Department has 93 U.S. attorneys' offices spread across the country. Their job is to prosecute federal crimes, enforce federal law, and represent the United States in legal proceedings. That's what they exist to do. But this directive flipped that mission on its head. It told every single one of those offices to become a data collection hub for building political dossiers on federal judges, specifically targeting judges whose rulings the administration didn't like. We're not talking about investigating actual misconduct. We're talking about compiling rulings, legal decisions, the very thing judges are constitutionally empowered to make. The executive branch was mobilizing its entire prosecutorial apparatus to build impeachment cases against judges for doing their jobs. That's not a normal use of DOJ resources. That's the conversion of the most powerful law enforcement institution in the country into a political weapon aimed directly at the judiciary's independence. Now let's talk about the other side of this two-front confrontation, because the story has a mirror image happening simultaneously. Democratic Representative Al Green filed his own impeachment resolution, House Resolution 939, with an article that specifically cites Trump's threats against federal judges as an impeachable abuse of power. The language is devastating. It accuses Trump of making threats and vituperative comments against judges, putting their safety and well-being at risk, and fundamentally undermining the independence of the judiciary. This isn't vague political rhetoric. It's a specific constitutional charge linking Trump's public attacks directly to the safety crisis facing federal judges. And the reporting backs that up. Reuters and Politico have documented that federal judges, including some appointed by Trump himself, have gone to Congress with urgent warnings. They're telling lawmakers that Trump's rhetoric and the constant talk of impeachment threats are fueling a dramatic spike in real-world threats against judges. The judiciary has been forced to request significant increases in security funding just to protect its members. So when Green's resolution talks about putting judges' safety at risk, it's not hyperbole. It's documenting a pattern with deadly serious consequences. This is the two-front dynamic that makes the moment so extraordinary. On one side, you have the executive branch using the impeachment mechanism to threaten judges who rule against the administration's agenda. On the other side, you have members of Congress using the impeachment mechanism to hold the president accountable for threatening those very judges. The same constitutional tool is being deployed in opposite directions simultaneously, creating a feedback loop where each side's use of impeachment intensifies the other side's justification for using it in return. Let me dig into why the DOJ's egregious rulings compilation is the most institutionally dangerous element of this entire story. When the Deputy Attorney General uses the word war to describe the administration's posture toward the judiciary, that's not casual language. It reveals a mindset. War is what you wage against an adversary. War is what you fight when you want victory, not balance. And a a Justice Department that sees itself at war with the judiciary is a Justice Department that no longer sees its role as defending the constitutional order. It sees its role as executing a political strategy against a co-equal branch of government. The directive to all 93 U.S. attorneys' offices to compile rulings for potential impeachment referrals is the operational expression of that war mentality. It's the institutional machinery of the executive branch being systematically redirected toward undermining the independence of the judicial branch. And here's the constitutional heart of the problem. Article 3, judges serve lifetime terms precisely to protect them from this kind of pressure. The founders wanted judges who could rule based on the law without fear of losing their jobs because they made the president angry. That's not a nice-to-have feature of the Constitution. It's a deliberate design choice. When the DOJ builds an institutional process for identifying judges to impeach based on their rulings, it's attacking the very core of that constitutional protection. Now let's look at the coordinated nature of what's happening, because the pieces fit together in a way that reveals a clear strategy. First, Trump demands Boasberg's impeachment publicly. Then, the DOJ launches its nationwide compilation of egregious rulings. Then, a freshman Republican files impeachment articles against Boasberg with 5 co-sponsors. The sequence, presidential demand, executive branch preparation, congressional action, looks less like spontaneous political outrage and more like a coordinated campaign using every lever of government to intimidate the judiciary. And Boasberg isn't the only target. Similar impeachment resolutions have been introduced against other judges whose rulings angered the administration. This is a pattern, not an isolated incident. Chief Justice Roberts understood exactly what he was doing when he issued his rebuke. He wasn't just defending one judge. He was articulating a constitutional principle that applies to the entire situation. Impeachment is not a remedy for disliking judicial decisions. That statement is now permanently on the record as the judiciary's official response to the most direct threat to its independence in the modern era. And it's a principle that cuts both ways. It applies equally to the coordinated campaign to impeach judges for their rulings and to the president whose threats about those rulings prompted impeachment articles against him. Let me bring you back to the Green Resolution for a moment, because the specific constitutional argument it makes deserves careful attention. Article 2 of Resolution 939 cites Trump's threats against judges as an impeachable abuse of power. That's a significant claim. It says that when a president uses the power of his office to publicly attack and threaten federal judges, creating real-world safety risks and undermining public confidence in judicial independence, that conduct crosses the line from political speech to constitutional offense. And the resolution ties that claim to documented facts: the spike in threats, the security funding requests, the judges themselves warning Congress that the rhetoric has consequences. This isn't speculation, it's evidence. So, what we're watching is a constitutional confrontation with no modern precedent. The impeachment mechanism was designed for rare and extraordinary circumstances, but right now it's being simultaneously weaponized in both directions. One faction is using it to target judges whose rulings block executive action. Another faction is using it to target a president whose rhetoric endangers those judges. And caught in the middle is the judiciary itself, an institution that relies on public confidence and independence to function, now facing unprecedented pressure from both the executive branch and Congress. Let me give you the 4 things you absolutely need to understand about where we stand right now. First, the DOJ's egregious rulings operation is the most alarming institutional development in this entire story. When the executive branch uses its law enforcement apparatus to systematically identify judges for potential impeachment based on their decisions, it's not just political gamesmanship. It's a direct assault on the constitutional design that protects judicial independence. That operation is ongoing, and its continuation will determine how far this confrontation escalates. Second, the Republican judicial impeachment campaign, with the Gill resolution and its co-sponsors, represents a coordinated effort to use Congress as a tool for disciplining judges whose rulings the administration opposes. The coordination between presidential demands, DOJ preparation, and congressional action creates a pattern that cannot be dismissed as isolated or spontaneous. It's a strategy, and it's being executed across multiple fronts simultaneously. Third, the Green Resolution and its specific citation of Trump's judicial threats as impeachable conduct establishes a congressional record that will matter for years to come. It documents the link between presidential rhetoric and the real-world security threats facing federal judges, and it provides a constitutional counterweight to the judicial impeachment campaign, creating the two-front dynamic that makes this moment so historically significant. Fourth, the Roberts rebuke stands as the judiciary's authoritative statement of the constitutional principle at stake. Impeachment is not a remedy for disliking judicial decisions. That principle now sits permanently in the institutional record as the line that cannot be crossed without undermining the very structure of separated powers the Constitution creates. So here's where we go from here. 3 things to watch. First, will the DOJ actually formally refer any judges to Congress for impeachment based on the compilation operation? If that happens, the confrontation escalates to a level we've never seen before. Second, what happens to the Green resolution? In a Republican-controlled House, it's unlikely to move forward now, but the political landscape could shift, especially depending on what happens in the midterm elections. Third, keep watching the judicial security situation. The spike in threats that Reuters and Politico documented is not abstract. It's real, it's dangerous, and it's directly connected to the rhetoric coming from the highest levels of government. Let me leave you with the bottom line. Donald Trump demanded the impeachment of a federal judge for issuing a ruling he didn't like. The Chief Justice of the United States publicly rebuked that demand, stating that impeachment is not a remedy for judicial disagreement. The Trump Justice Department directed all 93 U.S. attorneys' offices to compile egregious rulings for potential impeachment referrals, while a senior official described the administration's approach to the judiciary as a war. A freshman Republican filed impeachment articles against that judge with 5 co-sponsors, and simultaneously, a Democratic representative filed impeachment articles against Trump, specifically citing his threats to judges as impeachable abuse of power. The impeachment weapon is being deployed in both directions at once, against judges for their rulings and against the president for his threats about those rulings. This is the most extraordinary two-front constitutional confrontation in modern American political history. Stay tuned. The DOJ compilation continues. The impeachment resolutions sit on the congressional record. The security threats against judges are rising, and we are going to be right here covering every development as it unfolds. If you're not subscribed yet, hit that button right now. Drop a comment below. Do you think the DOJ actually formally refers a judge to Congress for impeachment? And what happens to the constitutional order if that line gets crossed? I want to hear from you. I'll see you in the next video.